Our next witness is going to be our expert witness, Ms. Bahar Saba.
Thank you.
And it's in page 419 of your supplemental.
Ms. Saba, thank you very much for attending, and if you just repeat after me, please. I solemnly declare that I will speak the truth.
I solemnly declare that I speak the truth,
The whole truth and nothing but the truth.
the whole truth, and nothing but the truth.
I think you've seen how it goes, so first of all, questions from council and then questions from the panel. Thank you.
Ms. Saba, I understand today you have a presentation, but before you begin, could you please introduce yourself and tell us your professional background, which qualifies you as an expert today?
Thank you. Thank you for the opportunity to testify before the tribunal. My name is Bahar Saba, and I am a human rights researcher. I obtained my law degree in Iran and subsequently obtained an LLM in international human rights law and an MPhil in modern Middle Eastern studies in the UK. Over the past decade, I have worked for multiple international human rights organizations investigating and researching human rights abuses in different countries in the Middle East and North Africa, including in Bahrain, Egypt, Saudi Arabia, and the United Arab Emirates, although my primary focus has been on Iran throughout.
You may proceed with your presentation.
Great, thank you. So in this statement, I will be focusing on the use of potentially lethal force, referred to in international standard instruments as less lethal force, by Iran security forces during the November 2019 protests. Therefore, the use of live ammunition falls outside the scope of my research. This is notwithstanding the fact that a significant number of witnesses have reported seeing both the use of less lethal weapons as well as live ammunition by state security forces. My professional assessment has been primarily based on witness statements obtained by the Auburn Tribunal. I accessed these statements as part of my work as a legal consultant on a joint research done by the Karlshofen-Rieskes Forum of Leiden University and Justice for Iran into the violations that were committed in November 2019. In addition to the 67 witness statements I have studied, I have reviewed video footage of protests verified by Amnesty International, images of injuries sustained by witnesses, and reports of credible human rights organizations and UN experts. The evidence I have examined clearly demonstrates that Iran's security forces used a wide range of potentially lethal weapons in November 2019. Some of these weapons, as I will come to explain, should be prohibited and must not be used under any circumstances. Other types of weapons, which may have a legitimate law enforcement use, were deployed in a manner that violated international law and the physical and mental integrity of protesters and bystanders. These weapons, as I will explain in this statement, have caused severe, irreversible, and even fatal injuries. Overall, force was used with the intent to punish and intimidate the protesters and to cause pain and suffering, with the overall objective of repressing the protest at the cost of killing and causing serious or irreversible injuries to the protesters and bystanders. The use of potentially lethal force in violation of the strict standards under international law was not restricted to isolated incidents. Rather, such use of force was seen across the country in a wide geographical scope, causing serious injuries to both protesters and bystanders in different cities. Witnesses whose statements I have studied have testified about the use of potentially lethal force in 28 cities in 16 provinces. In the course of November 2019 protests, Iran security forces deployed multiple shot pellets, both rubber and metal, chemical irritants, water cannons, batons, and stun guns. I must note that this is not an exhaustive list. Rather, these are the weapons that were most commonly used, and other types of weapons were likely used by Iran's security forces. I'd be grateful if we can please have the slides. I think this is the previous version. So just the slides, I am going to show some of the weapons that I have looked at. These weapons, the images are not from the ones that were used during the protests, but are taken from a visual guide to law enforcement equipment that was published by Omega Research Foundation, which is an independent research organization that works on the global manufacture, trading, use of military security and police equipment. Only the last image was used, it's of water cannons that are used in Iran. Yes, thank you. So witness testimonies, injury images, and research by human rights organizations provide strong evidence that Iran's security forces used multiple-shot metal pellets, which are referred to as birdshot and buckshots. These are metal projectiles that can range from small birdshot pellets to larger buckshot balls that are generally fired from shotguns. As the name suggests, these are ammunition that are designed for hunting and therefore penetrate soft tissue. Multiple-shot metal pellets are indiscriminate, cause grievous and painful injuries, and are completely inappropriate for use in all policing situations, including policing of assemblies. So if you can see in the image, cartridges are filled with multiple pellets. Depending on the size of the pellets, there could be tens or even hundreds of pellets in one cartridge. And these are sprayed and scattered across once shotguns are fired. Despite the serious risk that posed to the life and physical integrity of individuals, security forces widely use multiple-shot metal pellets, such as birdshots. Metal pellets were shot from close range. As mentioned, these pellets are inherently indiscriminate and cannot be aimed. However, the manner in which security forces fired them further exacerbated their indiscriminate nature. For example, forces fired metal pellets from elevated positions, increasing the risk of individuals, including bystanders, being shot in the head and face and shot at individuals fleeing. According to witness testimonies, security forces also deployed multiple-shot rubber projectiles. If we can please have the next slide. So these are also indiscriminate and inaccurate and cannot be aimed at a specific individual. Therefore, they should not be used at all. If there were any situations where there were genuinely a risk of injury, under international standards, Iran's security forces could only use a specific type of kinetic impact projectiles, that is single projectiles specifically designed for crowd control. If you please have the next slide. Thank you. So these are single, less lethal projectiles, such as single rubber balls or foam-tipped projectiles. These are the only types of projectiles that may be used in exceptional circumstances, that is to target the specific individual posing the imminent threat of injury. They cannot be randomly and indiscriminately fired at crowds. I have not had access to evidence showing whether and to what extent they were used in November 2019. Furthermore, I must note that as Amnesty International has concluded, barring 2 incidents where there was an exchange of fire, there is no evidence that people were in possession of firearms or that they pose an imminent threat to life. Chemical irritants, if we can please have, thank you. These are a group of chemicals that produce sensory irritation and pain in the eyes, upper respiratory tract, and skin. They include tear gas and pepper spray. Tear gas is indiscriminate and by design and should only be used in situations of more generalized violence as a measure of last resort and following a verbal warning. Video footage and witness testimonies show that the security forces excessively and widely resorted to the use of tear gas without issuing any prior warning, and in order to disperse protests and where protests were peaceful. Security forces also shot tear gas canisters along a flat and direct trajectory into the crowd, resulting in individuals being hit with canisters. In some instances, security forces shot tear gas canisters into homes and other confined spaces, or while on motorcycles, or from elevated positions. Can we please have the next slide? Thank you. Batons, these are probably more familiar, a type of striking weapon. It seems that straight and side-handled batons are more commonly used in Iran. Batons shall not be used against a person who is neither engaged nor threatening violent behavior that is risk of injury. Yet evidence I have examined clearly demonstrates that security forces used batons against individuals who posed no risk of injury, against peaceful protesters and bystanders, and in order to disperse people. Security forces targeted sensitive body parts, such as people's heads, necks, and faces. They chased people fleeing and struck with batons powerless individuals already restrained or otherwise under their control. Can we please have the next slide? Thank you. Electric shock weapons deliver an electric shock to a target individual. Only certain types of electric shock weapons may be used where there is a real and immediate threat to life or risk of serious injury. A number of witnesses whose testimonies I have studied describe the use of what they refer to as shockers, and from the description and the circumstances of use appear to be stun guns. Stun guns must not be used as the risk of arbitrary force amounting to torture or other ill treatment is too great. Thank you. Water cannons are high-pressure systems which shoot streams of water. They are often mounted on vehicles. Similar to tear gas, water cannons are indiscriminate by nature and can only be used in situations of more generalized violence as a measure of last resort. Existing evidence shows that water cannons were used in order to disperse peaceful protests, and in 2 videos, security forces are seen using water cannons against peaceful protesters who are chanting slogans with the aim of dispersing them. I must note here that, as stated by the Human Rights Committee, isolated acts of violence will not suffice to taint an entire assembly as non-peaceful. Rather, an assembly can be considered non-peaceful where violence is manifestly widespread. The number of those who sustained injuries with multiple shot pellets, batons, tear gas, stun guns, and other potentially lethal weapons is not known. Given the types of weapons used and the manner in which they were used, it is reasonable to assume that a significant number of people sustained injuries during the protests. These injuries could have included those that are typically associated with the described potentially lethal weapons. Injuries such as total and permanent loss of vision, bleeding in organs, muscle and bone injuries, bruising and contusions of the skin and soft tissue, superficial or deep lacerations, concussions and bruisings inside the brain, skull fractures, suffocation, burning and blistering of the skin, and cardiac arrest. Indeed, some of these injuries have been reported by witnesses. I am not able to comment on the number of deaths caused as a result of these weapons. With respect to the fatal consequences of the use of tear gas, Amnesty International knows of 2 individuals, Yadullah Haji Taripur and Ziba Khoshgawar. With respect to multiple shot pellets, Amnesty International knows of the case of Bahman Jafari, who died from injuries resulting from being shot by multiple metal pellets all over his body. 2 other individuals, Mohsen Mohammadpur, a child, and Faramarz-Pur Asadi, were killed as a result of fatal head injuries, reportedly as a result of beatings. It is highly likely that a larger number of individuals than those already identified were killed as a result of the state forces' use of potentially lethal weapons. The use of multiple shot pellets, in particular metal pellets, has resulted in protesters and bystanders sustaining disabilities, such as permanent loss of vision. In correspondence with Amnesty International, the organization shared information revealing that it had learned about the details of over 80 individuals who between 15 and 19 November, and in one city alone, had received specialized treatment for eye injuries sustained as a result of having been shot in the eye with pellets. Individuals also sustained penetrating trauma. Witnesses reported having been injured with a large number of pellets, from 3 to over 60 pellets, in various body parts, including in the face, head, neck, torso, arms, back, and legs. Witnesses also reported seeing others, including elderly individuals and children, being shot with pellets. I also have reviewed images of injuries of 5 witnesses who sustained injuries with pellets. The images vividly demonstrate injuries consistent with the spray patterns of multiple shot projectiles such as bird shots. Injury images show penetrating trauma, in some cases as many as 40 to 50 wounds, sustained in the back, face, legs, neck, and face of victims, consistent with their testimonies. Witnesses have also reported having sustained lacerations, bruising, and contusions of skin, broken or fractured bones, as a result of tear gas canisters being shot directly at them and being beaten with batons and other potentially lethal weapons. Not only state forces failed to provide medical care at the scene of the protests, they were present in hospitals, identifying injured individuals and making arrests. Almost in every single case where witnesses said they had sustained injuries, they reported that they had not sought medical care at a hospital due to fear of persecution. After examination of types of weapons used and the manner in which they were used, it is my conclusion that the use of potentially lethal weapons during the November 2019 protest amounted to torture or other ill treatment. In other words, all the elements of the definition of torture are present. Public officials intentionally inflicted severe pain and suffering on protesters and bystanders for the purpose of punishing and intimidating them, coercing them to cease protesting, and for discriminatory purposes. The injuries described earlier would have caused severe pain and suffering. Some victims were sprayed by metal pellets, leaving tens of penetrating and painful wounds across their bodies. These injuries have also had long-term consequences, including permanent disability and recurring infections, and must have caused significant psychological suffering. Infliction of pain and suffering was intentional. Generally speaking, intent means that a person means to engage in the conduct or to cause consequences, or is aware that the consequences would occur in the ordinary course of events. The types of weapons used and the manner in which they were used revealed that security forces either meant to cause the injury or death of the victims, or would have been aware that injury or death would occur in the ordinary course of events. Security forces use potentially lethal force against protesters in order to punish them for daring to participate in what the authorities consider illegal assemblies. They also used force in order to intimidate protesters and bystanders and to coerce them to cease protesting. And finally, these weapons were used on discriminatory grounds, that is, on the basis of protesters' political opinion. There is mounting evidence that the forces who used these weapons were state agents. A large number of witnesses have identified various security forces, including uniformed forces belonging to the police, as forces who used potentially lethal weapons. Video footage also shows forces using tear gas and batons and discharging weapons. As stated by witnesses and seen in some videos, where plainclothes forces are present, they are in proximity to or are acting in collaboration with uniformed forces. To conclude, the widespread manner in which security forces use potentially lethal force across the country violated all principles of the use of force. Security forces used weapons which must be prohibited, including multiple-shot metal pellets and rubber pellets, and used force in circumstances not allowed under international law, including against individuals who posed no threat of risk or risk of serious injury, and for achieving objectives that are not legitimate, including for dispersing peaceful protests. Such conduct violated the rights of protesters and bystanders to be free from torture and other ill treatment, and diminished their human dignity. To date, no investigation into cases of torture and other ill treatment has been carried out by the Iranian authorities. Such refusal constitutes an ongoing violation in itself. Thank you. I will conclude here and would be happy to answer any questions.
Thank you. The first set of questions or question I have relates to the law, and then I'm going to move on to self-defense. Your report, specifically on page 36 and for the panel, page 453, paragraphs 128 through 131, discusses Iran's regulatory framework or legal framework around the use of weapons or firearms. And my understanding is, and it is a novice understanding of the Iranian constitution, is that Article 27 generally speaks to the fact that people are allowed to hold assemblies and marches without weapons, carrying weapons, and as long as it doesn't violate the essentials tenets of Islam. And under Article 38, there is a general prohibition of torture. But the references that you make to in the law here indicate that there's actually no framework that regulates the use of firearms. Can you explain why there's a discrepancy when the Constitution appears to give more protections to people as opposed to the laws?
Correct. So the Constitution, as you mentioned, provides general guarantees of the right to assembly and freedom from torture and other ill treatment. However, these constitutional guarantees are qualified by broad and vague phrases such as long as they do not interfere with principles of Islam. And in the case of torture, the qualification is that torture is prohibited when it's for extracting confessions. Therefore, leaving out when torture is committed for any other purposes, for example, for punishing individuals, for humiliating them, and when torture is committed for discriminatory reasons. And when it comes to the issue of assemblies, the Constitution says that assemblies are permitted as long as individuals do not carry arms. However, what happens is that individuals need to seek licenses and receive licenses in order to be able to have legal assemblies. Now, the law that governs obtaining of licenses is the 2016 law on operation of political groups and parties. Under this law, political parties it's one of their privileges that they can request licenses to hold assemblies. The law does not specify any specific avenues for individuals who are not within political parties to request licenses. And then when we look at the criteria that governs political parties, we realize that there are specific conditions that should be met. For example, if you want to start a political party, you must believe in Asl Velayat Faqih, or the jurisprudence of an Islamic jurist. There are also other criteria. For example, you must not have been convicted of any national security charges and such, and that already excludes a large number of journalists, human rights defenders, and others. So this means that only individuals or parties who are within this very, very restricted framework can seek a license to hold an assembly. There is no avenue for individuals outside of this, and this is something that officials of the Ministry of Interior have themselves acknowledged, that there are no avenues for individuals to seek a license. Any assembly that does not have a license is automatically considered illegal. And under the law on police forces, the police forces can disperse and crush assemblies that are illegal, even when they are peaceful. So effectively, while there is a constitutional guarantee, albeit very weak, under the other legislation, it is not possible for individuals who, for example, want to protest a certain decision by the government to seek a license. Their assemblies, no matter that it is peaceful, would be considered illegal and will be crushed.
So when you say crushed, and if I understand you correctly, there is a standing order then that violence can be used against people who would want to protest?
So yes, this is where we get to the law on the use of firearms by law enforcement in necessary instances. Under this law, as the previous expert mentioned, there is no threshold in a way that it must be established under international law for the use of firearms. So under international law, firearms could be used as live ammunition or lethal force when there is an imminent risk of death or serious risk of injury. An intentional shooting could happen only to preserve life. That is the only circumstances. So the law on the use of firearms by armed forces in necessary instances does not provide for this threshold. First, under Article 3, we do have the text of the law in Persian. If it's necessary, we can show it. So under Article 3 of the law, it lists a number of conditions under which firearms can be used. They include, for example, to defend themselves against an individual who attacks them with warm or cold weapons. No mention of imminent risk. In general and broad terms, it speaks about attack. Similarly, for defending themselves against one or several unarmed persons who launch an attack, but the circumstances is such that self-defense without the use of a firearm is not possible. So there are multiple other, I'm not going to read through them. I will be happy to provide that later. But amongst those circumstances under which firearms can lawfully, in quotation, as in under Iran's law, be used, is for protecting buildings belonging to the police, such as headquarters, police stations, weapons and armory storage and training grounds, or for protecting police, military, and security facilities, equipment, and buildings, or even for preventing individuals who want to cross borders illegally. So none of these circumstances that are mentioned provide for that very high threshold where the use of firearms is allowed exceptionally under international law. And I must say that firearms or live ammunition is not even defined in this law. It is by the context of the law that you realize this is firearms. For example, it says that you should first fire into the air, then someone's leg, and then shoot to kill, which you would not do by any other weapons other than firearms. So it is about firearms, but there is no definition of firearms. And then when it comes to protests, again, the law allows for the use of firearms for controlling protests, illegal assemblies, unrest and riots, which their control and where returning order is not possible without the use of firearms. So this is not about armed assemblies, and that is clear. Why? Because under Article 5 of the law, it deals with armed protests. So there are two separate articles. So Article 4, according to which law enforcement is allowed to use firearms, basically to disperse a protest, is about unarmed assemblies. And determination of what assemblies would fall under this would be considered illegal assemblies, unrest, or riots, is with the security department of the province. There is no clarity, as far as I'm aware, as to on what basis, on what criteria they make a determination of when an assembly is considered to have reached a level where firearms is used, and there is absolutely no transparency about these decisions and the way they are made, and they're not made public, apart from the fact that we know that the order has been issued, but we do not know the proceedings that led to it.
Great, thank you. I'm gonna move on now really quickly to the area of self-defense. And your report is very detailed, and it's very technical as well. But generally speaking, what I have gathered from your report is that force is only appropriate in terms of self-defense, and self-defense meaning to protect a life, okay? So you studied statements and videos that were provided by the Aban Tribunal team, and you also looked at Amnesty International's information. I was wondering if you could, before I get to my questions, explain your methodology as to what you were looking for and what kind of evidence you needed to make your assessments for this report.
So as stated, I have looked at 67 witness statements. These statements have been from 28 cities and 16 provinces. I have not looked at other provinces where witness statements have been present, purely because it was an issue of time constraints. There are more testimonies about other cities and provinces that should be studied. I have chosen the statements more on the basis of the geographical scope. I have tried to look at testimonies that have been from different cities and different provinces. And once I read one statement from a specific city, I tried to find other testimonies that dealt with the same city in order to be able to discern a pattern described by witnesses, and also to use different witness testimonies to basically assess the credibility and corroborate them with each other. And also I've used verified videos that existed. I must say that I have looked only at the verified videos that Amnesty International has published. Those are about 130. As the previous expert also mentioned, there are hundreds and hundreds more video footage in which potentially lethal force has been used. These have not been verified yet, and although I'm able to verify videos, it's a very time-consuming process. Therefore, I have only relied on videos that have already been verified. But given that the focus of these organizations has been on the use of lethal weapons, so live ammunition, there aren't as many videos verified where the use of potentially lethal force is depicted. However, there are a number which I have reviewed, and some other pieces of video also show the more general context, as in whether it was peaceful, individuals were chanting, and so on. So I have looked at these evidence. And again, in the cases where injury images were available, I have reviewed those as well, and again have looked at all the evidence against each other, but also against the general patterns of human rights violations as documented over the past decades by the UN experts and also human rights organizations.
Great. So with that in mind, with everything you evaluated, how many of those statements or videos did you see force being used by the people or the protesters?
So I must give a bit more details about principles of the use of force. So the general principles of use of force are legality, necessity, proportionality, accountability, and precaution. That means that any use of force, whether it's potentially lethal or lethal, should be very clearly and precisely written down in a law. And force is only allowed when it's for a legitimate reason. So that is to protect against a risk. Now, depending on what weapons are used, whether they're lethal or potentially lethal, and even when you look at potentially lethal weapons, there are slightly different standards that apply. But proportionality means that even when there is a legitimate, so for the use of lethal weapons, there is a protect life principle. So that basically means that a life could be put at risk only and only when it is for protection of another life, no other circumstances, no protection of property. And any force that's used should be proportionate to the aim that's legitimate aim that is meant to be achieved. So not all, basically not all even legitimate law enforcement objectives could be achieved at any cost. So if you want to protect, for example, against vandalism, you are allowed under international standards to use certain types of weapons, but you cannot do that at any cost. So there always needs to be a balance between basically what you are going to protect and the force that you are using, and you cannot do more harm that would be caused if you did not do that. And also the least amount of force should be used only when absolutely necessary. So according to evidence that I have looked at, witness testimonies and video evidence, there is a very, and again, as I said, this is, there will be so much more evidence out there that should be studied. However, even this partial evidence depicts a very clear pattern, general pattern of use of force by security forces across the country. So force, basically, weapons were used that should not be used at all, regardless of the circumstances. So the pellets that I showed, those are prohibited because even if there is a risk in a situation and a specific individual is posing a threat, you would not be able to aim at that specific individual. Inevitably, if you use multiple shot pellets, you would spray them and injure a number of people, and you would not also be able to target a specific part of that person. So overall, what I have seen, it's not that force was used for any legitimate purpose. Overall, there is a very clear pattern of force being used to disperse overwhelmingly peaceful protests, and where some level of force, for example, could have potentially been used, they were used in a manner that's not allowed, for example, firing tear gas directly at people. So overall, the aim was to make people stop protesting.
Okay, and then my last question, I'm going to hand it over to the panel. I want to focus really quickly on specially protected groups, so specifically children, people who are handy-capable or disabled, as some may say, and the elderly. In the evidence that you analyzed, how was force used against these groups, if at all?
So the evidence that I have looked at shows that the weapons that are prohibited, such as multiple shot pellets, were used, as well as weapons that are inherently indiscriminate, such as tear gas and water cannons, where children were present, where elderly individuals were present, and at least in one instance, there is a testimony that someone who had a disability was present and injured as well. So with regards to children, for example, a witness stated that tear gas was fired inside their home, which already is illegal because tear gas should not be fired inside confined places because it could cause suffocation, where his children were present. And then when the person went inside to object to the security forces, he said that he was threatened with arrest. One witness also said that tear gas was used so excessively that was reduced visibility, and there were a mother and a child, and the child was lost because no one could see around. And as I said, similarly, pellet rounds were also used, including against children. Witnesses have said that these were shot indiscriminately and meant that children were injured as well. One witness said that they saw a child around 8 or 9 years old being shot in close proximity to the eye, while another stated that they saw a 15 or 16-year-old child being shot in the eye. And the witness believed that the injury was of such a gravity that the victim would have lost his vision. And again, as mentioned, in correspondence with Amnesty International, the organization said that it had learned about the details of over 80 individuals who had sustained eye injuries in one city alone. And 7 of these individuals were children, that is, they were under the age of 18 at the time they sustained injuries. Similarly, with batons, witnesses have said that forces were subjecting individuals indiscriminately, and they struck anyone who was within their reach, including children. And I must note that while these weapons are dangerous for everyone and could cause severe injuries in everyone, there is research that shows that children, because they have reduced body mass and immature bone growth, they are more susceptible to severe injuries. And any weapons, for example, who penetrate soft tissue is more likely to cause internal injuries in children because of this reduced body mass. Similarly, it seems that the impact of chemical toxins that are used in tear gas is more likely to cause severe injuries in children.
Thank you so much, Mr. Chair.
Thank you for your presentation. I have one question. It's a general question, really dealing with the parameters of the definition of torture, and I'd like to get a better understanding of how you see that, because, to be perfectly honest about it, it appears to be a broader understanding that I have, at least under international law, and I'm not suggesting I'm an expert in Iranian law, but under international law about what torture is. And so my question is this, and I'd like your opinion as to whether this could constitute torture. If there is a protest, a large protest, a noisy protest, there is no permit or license for it. It is illegal under the law. Individuals have not engaged in violence yet of any kind, the protesters. And the police are under an order to regain order in the area. So they use water cannon indiscriminately. By definition, it's going to be indiscriminate. They use tear gas, and then you have police running through the crowd using batons on individuals randomly, whoever happens to be closest to them, as you point out. And it's clear also that this protest is a protest against a government policy. There's definitely a political reason for it, and that would be why the government wants to shut it down. Would that set of circumstances, according to your view, constitute the use of torture in the response to the protest?
Yes, so there has, I think, been a kind of focus more or less on torture and other ill treatment in custodial settings. So that is when individuals are in the state's custody, detention centers, police stations, or prisons. However, there is growing international jurisprudence, including before the European Court of Human Rights and the Inter-American Court of Human Rights, where the use of the weapons that I have described against protesters have been considered to have constituted torture or other ill treatment. There is a specific case, for example, in Italy, where security forces subjected individuals, protesters who were peaceful, to beatings with batons, and the European Court concluded that this diminished their human dignity, and the severity of the pain and suffering meant that this actually constituted torture. There are similar cases in Azerbaijan, in Turkey, with the use of tear gas and other weapons. So in a setting where peaceful protesters are peaceful, there is absolutely no permission under international law to use any force whatsoever. The fact that an assembly is not licensed, has not received prior permission, or even the organizers have not notified the authorities in breach of domestic laws, none of these would render an assembly illegal or non-violent, in fact. And use of force is prohibited to disperse assemblies that are peaceful.
So just one follow-up. So if the situation was that the assembly, which, for example, I believe happened in the situation before us, was filling up the city streets, no traffic was possible. Again, no one's being injured. but the city is shut down because of that assembly. Are you saying that the authorities then are really powerless to do anything about that?
No, so it is possible under international law for authorities to take some action if the level, so just blocking of the roads for some time, and there is no specific time specified under international law, but blocking of roads is a peaceful act. And the fact that it causes disturbance or annoyance, that's not enough. However, yes, if a certain threshold passes and everything is in such a chaos, authorities are allowed to take force. However, that does not mean that they are allowed to use force. There are various steps that the authorities must exhaust before resorting to any force. So first, they must de-escalate, even if there is a possibility of things becoming volatile. So they need to negotiate, they need to hear, and they could when they can take action, for example, if there is generalized violence, for example, if they can use some of these weapons, for example, tear gas, which could potentially be used if there is generalized violence and there is damage to property. They still would need to abide by all the principles of use of force. So they cannot shoot directly at an individual. So even if the setting, the circumstance would allow the use of tear gas, the manner in which it is used, so let's say security force A shoots at someone with the intent to actually force them to leave a tear gas canister, and that hits their head and it causes injury. So depending on the reason, the purpose, so it is possible that it would amount to torture. However, I think what we are seeing in the case of Iran is not policing that has gone wrong in certain instances. So there is a very clear pattern that security forces have used all in their possession in terms of these weapons in order to disperse immediately after individuals took to the streets. In fact, in many instances, they escalated the situation. They started using tear gas. They started using pellet rounds at individuals, even when they were fleeing. There are video images that show security forces arresting an individual, so someone who's already restrained, regardless of why that person was restrained, they are subjecting that person to beatings with batons. That is not legitimate. So that does not constitute a legitimate use of batons because that's a powerless individual. So again, these are not incidents that have happened because certain security forces thought that the situation is out of hand and they made some mistakes. There is a very clear pattern of intentional use of these weapons. A lot of them, like stun guns and pellet rounds, must be prohibited. They are not allowed to use them at any setting against individuals. So again, this is not sporadic instances of force being used excessively, but it's unlawfully with the specific purpose of making individuals leave the scene.
Justice Yacoub.
Thank you very much. Hello, yeah, thank you. Just as one lawyer to another to start with, I very often
Justice Yacoub, could you get closer to the microphone?
Okay. Yeah. Thank you. Is that clear? Okay. Just a light point. I find it difficult for you to understand the rest of the questioning as well. I find it difficult to understand the distinction between strictly necessary and absolutely necessary.
Apologies, I'm still not hearing well.
I find it difficult to understand. You see, if I sound loud, I might sound too severe, and I'm a little worried about that. But I find it difficult to understand that for the sake of emphasis, you would say absolutely, absolutely necessary. But would you agree with me that, strictly speaking, necessary is necessary, strictly, absolutely, or not? Or do you think that there are different standards of necessity?
So under international law, there are general principles on the use of any force. And then there are more specific standards that are there for specific types of weapons to be used. Within this framework, which is very, very strict, law enforcement has a level of discretion. But that discretion means that they need to assess the situation and respond while respecting all these principles. So international law cannot come and say that this is a list of scenarios in which you cannot use force or where you can use force specifically. There is an area of discretion.
Sorry, you misunderstand me. Is there a difference in standard if you say you must do something when it is necessary, or you say you must do something when it is absolutely necessary? Because absolutely necessary would mean that you can do it. You can't do it when it's necessary. You can only do it when it's absolutely necessary. Is there necessarily a distinction? Or do these words of emphasis tend to cloud the issue usually?
So absolutely necessary means that there is no other way.
What does necessary mean? That there is another way?
So I'm not sure if legally speaking...
No, sorry, I'm asking you honestly, what does necessary mean then? If you tell me, as a lawyer, absolutely necessary means there is no other way, then I'd like to know from you as a lawyer, I'm just trying to understand your language and what you mean so we can talk properly about these things. What does strictly necessary mean? And what does then necessary mean without the emphatic qualifications that one uses?
So the understanding that I have, and I think it's implemented across, is that absolutely necessary is when all other means that are less harmful are exhausted first, and there is absolutely no other way to achieve that legitimate goal but to use that. But beyond this explanation, I am not aware of any specific case law or anything that has differentiated between necessary and absolutely necessary. So
there's no case law which has used the word necessary and defined it that you've come across? Not a single one?
I have not.
Okay, that's fine. No,
I would not comment on that because I wouldn't want to speculate.
So have you come across cases which talk about strictly necessary?
The international standards use strictly necessary
So
as well.
do they make a distinction between absolutely and strictly?
Again, I do not know if there is any specific case law where this distinction has been made. But overall, that means that force.
All right. The next question I'd like to ask you, and sorry, it's going to be difficult again. If there is a crowd of 10,000 people, half bearing stones and rocks, and it's very noisy, and traffic is being blocked, and it lasts a long way, and the potential to cause grave damage, with lots of people holding cans of petrol and so on, and stones, etc., with slogans would say, kill the dictator, and so on. And you were advising the police as a lawyer, and you had the situation where they would do exactly what you wanted them to do. As an expert in international law, you are then told by the president, please organize resistance to this peaceful protest in a defensive way, but do absolutely nothing wrong. How would you do it?
So the General Comment 37, which is quite recent, does mention situations in which individuals are carrying things that could be assumed to be instruments of a potential crime. The mere carrying of such instruments, I'm not speaking about arms, but the mere carrying of them does not mean that individuals are going to do that. So that's a hypothetical scenario that there are a lot that would go into an assessment of someone who would give advice, because that would depend on a specific city, on a specific country, what sort of background of protests exists. So I'm not going to be able to say what I'd specifically say, because there would be a variety of factors that would need to be assessed. But any sort of planning for dispersing a protest where a threshold has passed needs to be also with the principle of precaution. That means that they need to look at whether children are present, whether elderly individuals are present, and what means they can use without causing harm. But beyond sort of saying these more general principles, it is not something that international law does, and again, because it depends on a variety of factors, I would not be able to say this is what I would specifically say.
That is as helpful as you can be in the circumstances. Is that correct?
Sorry, I did not.
That is your full answer to the question, or do you want to add anything more?
No, but I want to add, if we are, if this is a hypothetical question, that is yes, the answer. If the scenario relates to Iran, this is not what was the case. So the situation was not such that individuals were on the streets carrying gallons of petrol or carrying arms or anything that would mean that they are going to engage in acts of violence. Throwing of stones did take place. Witnesses have themselves said that we have, in some instances, have thrown stones at security forces, but we did that because they started firing at us with tear gas and pellets, and we wanted to make sure that they do not get too close to us and not harm us even more. And even throwing of stones would not justify a lethal response, and it would not justify the use of pellet rounds, multiple shot pellet rounds.
Believe me, I do understand these principles, and you stated them before. And I'm sorry, I thought I was asking a different question, but no further questions. Thank you.
Could I ask a few questions, please? First of all, just picking up where Justice Yaqub left off, I think what you said was you were discussing the water cannons, and I think you said that the use of them was indiscriminate, or rather they shouldn't be used on a crowd which was sorry, let me put it, I think what you said was to define a crowd as not peaceful in order to use the water cannon, you'd have to come to the conclusion that violence was manifestly widespread in that crowd. And I just wondered where that definition came from.
So that is a Human Rights Committee's General Comment 37, which specifies that. So this is actually established, it goes before and beyond this general comment, but the fact that a certain number of individuals may engage in acts of violence or arson or vandalism or any other acts does not necessarily mean that the whole assembly is violent, because it's always possible for law enforcement to make targeted arrests, for example, and not disperse the assembly as a whole with tear gas or water cannons. And even when there is generalized violence, and for example, there is destruction of property or acts of vandalism, the use of tear gas or water cannons cannot be used just to stop that. There again needs to be an assessment. For example, the UN guide on police equipment and less lethal weapons says that you still need to look whether elderly individuals are present, children are present, individuals who are, women who are manifestly pregnant are present. So that's when, if necessary, you can use tear gas, for example. But the generalized violence, that means that it's spread so much across the assembly that all of it as a whole can be seen as violent and non-peaceful anymore.
Thinking of a scenario, I mean, some of the videos we've seen, there's certainly people throwing stones in, I wouldn't say all of them, but many of them. There's certainly some burning of buildings. We've heard about that, from banks to vehicles to petrol stations. There's obviously a level of energy, let's say, and anger. Now, in those circumstances, would you argue that a water cannon to keep people away from, say, a petrol station would be inappropriate?
So again, that again depends on who's present. Are children present? Would risking, because water cannons and tear gas, they are assumed to be, their impact is assumed to be transient. It is assumed that someone would just leave without any harm. Water cannons could first, in cold waters, cause individuals to basically freeze. And also it's possible for the stream of water to propel individuals and make them fall, so they could have secondary injuries, or it could actually propel specific objects and they could be fired as missiles. So if there are, for example, lots of children present, but there are also some of these acts going on, there needs to be an assessment of whether harming these children would basically be as in a balance with protecting those properties. But again, if we come back to the case of Iran, in the cases where I know water cannons were used, according to video footage and witness testimonies, this was not the scenario. It was a peaceful protest in which no force whatsoever could have been and should have been used. So that was unlawful use of force. With regards to burning of buildings, I am not in a position to comment who were the actors who were beyond the arson. Again, as it has been mentioned, witnesses have spoken, they have persistently and consistently raised the allegation that it was not necessarily protesters, and it's possible that actors affiliated with the state committed these acts because of certain factors, such as them being very organized, arriving with motorcycles, and security forces being available and present and not doing anything. But again, regardless of who was causing the arson, acts of arson and destruction of property would, if there is no other way, more targeted way of, for example, arresting the individual who is causing arson or destruction, if it's a really large number of individuals, then yes, certain weapons such as tear gas or water cannons could be used.
But what about, sorry to interrupt, what about a crowd where there's several hundred people with 3 or 4 or 5 individuals determined to put the bank on fire, and the police or the security services are reluctant to enter the crowd for fear of exacerbating the aggression? Would they be entitled to use a water cannon?
If it's not generalized violence, no. So
what would they have to do then?
Because the impact of tear gas and water cannon is that they're indiscriminate.
No, but what would they do then in such a situation? If they're worried about going into the crowd because they're fearful the crowd would attack them, crowd's got stones, crowd is all hyped up, there's several people trying to light the bank on fire, surely the water cannon in that situation would be the lesser of all the other evils.
If the other individuals are acting in a way that makes it the violence generalized and there is no other way, yes, they could use it. Again, they cannot. So if they are harming the physical integrity of an individual, there should be very good reasons for it. Just protection of property alone would not allow that. So.
But they're faced then with an impossible scenario, aren't they? I mean, it's just not very realistic. They can't enter the crowd for fear of being attacked. They can't use weapons for fear of causing excessive...
No, they can use certain weapons.
But what weapon could they use in that situation, the one I've just outlined? If they can't use a water cannon, what could they use?
If it's really out of hand, I would imagine, again, if it's very specific scenarios, I think that's where international law does not get itself into as guidelines.
Yeah.
So that needs to be assessed prior. And it's not just, generally speaking, when it comes to policing of assemblies, it's also a lot of the planning and equipment, and it's a lot of de-escalation. So there could be other methods that could be used. Again, I'm not going to be specifically what they should do at that.
Yeah, but I can't think of a single thing you could do in that scenario other than use a water cannon. That's why I'm pressing you on it, because it seems to me, I take your point with the kinetic impact projectiles with guns and so on, but I don't know, my thought was the water cannon always seems to be a sort of, well, a useful instrument in a situation like I've just described. But what you seem to be suggesting is, no, they should use something else, but not
No,
suggesting what?
Sorry. Yes, I think they could, but again, there are different factors, so that's why I can't say they should use it or not, because they need to also see what temperature it is, whether tear gas might be something that's, for example, more appropriate for that scenario. If it's winter freezing weathers, then no. So that's a lot of specific factors that come in, but again, for the use of water cannons, they weren't as widely used as other weapons in Iran. So I think in terms of the hierarchy, the metal pellets, the bird shots that are used for hunting, those were one of the main ones that were used, followed by tear gas and batons.
Okay.
So water cannon was just in 3, I think, witnesses specified.
Yeah, okay. But, the metal projectiles, just to, so I understand, you identified them as being used because of photographs and videos of them, or because you assessed the injury and concluded that's what had caused the injury, or a combination of the two?
Apologies, the water cannons or...
No, what do you call them? The pellets, the bird shots.
Yes, bird
Yeah.
shots.
How did you assess that they had been used? Because there's photographs and videos of them, or because you assessed the injuries themselves?
So there were a large number of testimonies of individuals who were themselves injured as a result of the use of pellets. And some of them provided injury images. So these images show wounds that are basically consistent with the spray pattern of these pellet rounds. So that, for example, you would see the back of an individual with a large number of small wounds across. So I have not determined whether this was buckshot or birdshot, but pellet rounds of metal. In 2 of them, I have seen that they were metal. In some instances, they were rubber, but still multiple shot. And the information that was provided by Amnesty International about eye injuries, those were specifically caused by multiple shot pellets, whether rubber or metal. So there are injury images, consistent testimonies. With videos, there are not. I have not come across. There may exist. In the verified videos, I have not seen these being used, but I think there is a very simple explanation for that. And these, basically, these are indiscriminate pellet rounds.
Yeah.
So if they're fired, it's only reasonable that individuals would not stay in the vicinity to try to film, and they would run away.
Oh, so none of those weapons have been videoed or photographed?
It doesn't mean that it's not. I have not seen in the verified videos, but again, as I explained, the verified videos are more or less focusing on the use of firearms and live ammunition. So it's very likely that there are videos or still images that show that these were used. I'm also aware that there are media reports on the weapons that were used, and the shotgun weapons that are usually used for firing these pellets are visible in some of these images that exist. So it's possible that audiovisual images also exist, but again, I think there is a good explanation of why someone would not film or stay close to pellets, because they cause very serious injuries.
Okay, thank you. Last subject for me. I just want to try to understand the 1995 law on the use of firearms by armed forces in necessary incidents. This morning, as I understood some testimony, Article 4 allows armed forces to legally resort to firearms to control and suppress illegal assemblies. And as I understood the testimony this morning, the witness said there was no other qualifying legislation, that was the law. And once the Ministry of Interior then said that that was applicable in a given situation, then ground forces, security forces could then effectively use firearms to disperse or kill protesters. Your evidence suggests something a bit different, and I just want to make sure I understood it. Article 3 and Article 5. Article 3, I think you said, laid down some conditions when firearms could be used. Article 5 talked about what situation would prevail if protesters were armed. So these seem to qualify Article 4. They're relevant to Article 4, aren't they? So Article 4 isn't, as we heard this morning, such a broad authority just to use firearms on protesters. It's qualified by Article 3 and Article 5. Am I correct about that?
I believe that it is as broad as an authorization to use firearms in what is considered illegal assemblies. So Article 3, it's the examples that I gave. Those are not in the context of assemblies. Those are generally in all the settings where law enforcement is allowed to use firearms.
Why does that not apply to Article 4, though? Since Article 3, for example, I think what you said was firearms can be used when security forces are defending themselves against a number attackers who have weapons. So are you saying, maybe I'm not going to push you on this too far, but I just because it seemed to me your evidence was contradicting a witness this morning, you think Article 4 also then is a standalone article which enables, once enacted or once permission's been given by the Ministry of Interior, security forces to essentially do what they want with those firearms to get rid of the illegal assembly?
Yeah, I think it is a standalone provision because it specifically says that when in these scenarios, that is illegal assemblies, unrest and riots, where they're restoring order or controlling them without the use of firearms is not possible. So they can use firearms upon these two conditions. One is that they have used other means and it has not been successful, and that before using firearms, they have given an ultimatum to rioters and individuals involved in the unrest.
That's part of Article 4?
That is part of Article 4.
So Article 4 is qualified in that way then? Okay, that's so let me just jump from there to, if the Ministry of Interior then gives an order or sends a message down to the local level, Provincial Security Council, for example, that Article 4 is now in play, that doesn't mean to say that the security forces can just use arms whenever they like on an illegal assembly. They have to, one, give a warning, two, be sure that other means have been attempted.
That is the qualification, yes. However, this basically means that if there is an assembly that's considered illegal, which could very well mean a peaceful assembly that just does not have a license, and other illegal means for dispersing a peaceful assembly has been deployed, such as tear gas or pellet rounds, then they can give an ultimatum and effectively shoot at individuals who pose no threat whatsoever. So there is no threshold on individuals having posed a serious risk of injury or threat of death.
Sorry, I didn't follow that last bit. Could you say that again?
So again, as I explained, illegal assemblies are effectively assemblies that do not have a license. Yeah. Even if they're peaceful. So for these sort of unlicensed assemblies that are considered illegal, security forces and the police can disperse them, right? And if they think that they cannot disperse them and bring back order or control these assemblies without the use of firearms, they may use firearms dependent that the security departments have made that decision. In this scenario, they can, first, they must come and use against individuals who are not acting violently at all, other means. That means, for example, potentially lethal weapons. That already means that it's use of force when it's not legal, legitimate, necessary against individuals' right to peaceful assembly. And if using these potentially lethal weapons, which already is in breach of international law, does not work, then they can use firearms, which again is against individuals who are not posing an imminent threat of death or risk of serious injury, which is the threshold.
But I guess my point is slightly different in that just because I'm in the Ministry of Interior, I'm the minister, and I say Article 4 is now operable. It's not the same as saying go and shoot protesters. It's not the same as a shoot to kill order, is it? It's not on the face of it urging the security forces to kill protesters because of the qualifications built into Article 4.
Yes, but that then the practice comes into picture.
No, but I'm not. I just wanted to understand what the law itself said and what we need to look for in relation to other pieces of evidence. I've got nothing further. Thank you. Thank you.
I just want to clarify on that because I'm still not clear. So let's say the order that comes from the Minister of Interior does not. I guess my question is, can the order from the Minister of Interior veto Article 4? And so if an order comes to say all necessary measures to quell this, or to quell this protest, under Iranian law, leave aside international standards, we're clear on those. Under Iranian law, does that order have precedence over Article 4 and the safeguards built into Article 4?
So I'm not aware whether there is any other piece of legislation, and I'm not really aware of the proceedings and the manner in which these orders are issued and what exact wordings they're used. But I think in terms of the conditions which must be exhausted, I think they do not provide for the right to life, because they are not safeguards, because it's not protecting individuals who are not armed, who are not posing any threat from the use of firearms. And then I think practice is also very relevant. There is absolute lack of transparency about any of these decisions. The criteria and how they assess even any of these assemblies, why they determine that their control is not possible without the use of firearms, none of that is really clear, at least not under any legislation that's available, and I have not come across anything. It's possible there are internal documents on that.
Because the impression I've had from some of the evidence we've heard in the previous days is that there was not much discretion left to those who were positioned in places where they had to implement the order. For me, there's a bit of a contradiction of those who are on the ground that we've heard from, whether they were in security forces and have received the order. That message was clear to us that there was no discretion. When the order comes, effectively, it means shoot to kill. We're hearing a lot more nuance within the law, and what I'm trying to reconcile is how those two marry up, whether, and not in practice, but more, is there anywhere in the legislation or in any guidance that you're aware of that tells us, if you like, the order of precedence when it comes to an order from a minister versus, or this, or a higher up person versus the very clearly stated parameters in Article 4, or the more clearly stated parameters in Article 4?
So there are a few points, I think, that I'd like to articulate a bit more. So when it comes to, first, I think the issue of practice is quite important, because in many circumstances, Iran's laws, including when it comes to the use of lethal force, the laws are so flawed that even if they are implemented line by line and word by word, they would still not protect the human rights of individuals, including the use of force, lethal force. And then it comes the issue of practice. So what happens in practice? So if in practice, effectively what...
Sorry, I'm not interested in the practice. I mean, I just want to know if there is somewhere in regulation that says an order has more importance than this provision. Is there anything that would veto Article 4 when you're using force?
So I'm not aware of anything that would veto it as such. However, there is under the Penal Code for Armed Forces, there is a provision that specifically talks about the forces on the ground being bound to a level by the decisions of the security departments and the national security, country security council, that if they disobey such orders, they could be sentenced to imprisonment, and even they could be charged with muharaba, which is waging war on God. So they could potentially even be sentenced to that. So that decision from the security department and the national or country security council bears such level of authority. And I must also note that we are talking here about the use of lethal force. The other issue is that there is an absolute absence of legal framework on the use of potentially
No, that's
lethal
come
force.
through clearly. Thank you.
Yes, so there are no laws, and
Potentially lethal. Yeah, no, that's come very clearly through your presentation.
so individuals could use, law enforcement could use those without
Restraint.
accountability because there are no laws.
That's clear. Thank you very much.
I think that's it from the panel. Thank you, Council.
Thank you. Thank you, Ms. Saba.
Thank
Mr.
you.
Chair,
Thank you very much, Ms. Saba.
Thank you.
A very interesting report and evidence also. We'll take it into account for sure.
Thank you.